23 CR 2675, State of Texas versus Adam Hanlon. Can I have parties announced for the record for the state?
Travis Banks in the state of Texas.
Defense.
Angela Blake.
Are you Mr. Hanlon?
So,
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hanlon, I'm showing you what's entitled True Bill of Indictment.
All right, folks, buckle in. We're stepping into a Texas courtroom where the stakes are high and patience is low. The case, State of Texas versus Adam Everett Aguilar. What's on the line? His freedom and a harsh reality check about what happens when probation goes sideways.
Did you review that with your attorney? Did you understand it?
yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the state moves to proceed on the lesser included assault, bodily injury, family, class A.
Any objection?
No objection.
So the complainant in this case, is this complainant his wife or is this the daughter? Who is this complainant in relation to him?
Girlfriend.
All right. So what I can tell you all, this is not a plea agreement I'm not going to accept. Is the complainant aware of this plea agreement?
Plaintiff is uncooperative, so we have not communicated it to her since she told us she would not cooperate in this case.
All right. So is this 111 days supposed to be a judgment satisfied?
Yes, Judge.
All right. So I'm not inclined to give him 100. Did you
Let's
review
pause
that with
right
your
here.
attorney? Did you
Adam
understand
just
it?
pleaded true to
Counsel, do you waive
violating
the
his
reading of the
probation.
indictment?
In legal terms, that's
State,
an
are
open
you proceeding
admission.
on the
He's
indictment as
basically
presented?
telling the court,
Your Honor, the
yes,
state
I
moves
messed
to
up.
proceed on
The
lesser
catch?
included
That
assault,
single word,
bodily
true,
injury,
gives the
family,
judge full power
class A.
to revoke probation
Any
and
objection?
send him
No
to
objection.
state jail for up to 2 years. That's how fast
So
the
the
stakes
complainant
turn
in this
real.
case, is this company 11 days judgment satisfied on assaulting?
There are circumstances that he does have a partial defense to the case, Your Honor, but he is not pursuing it. There was the complaining witness did use a hammer on him during this incident,
Mhm.
and so he had injuries as well.
All right, I'll agree to 160 days based upon what you're telling me. I think that's more appropriate than 111 days. So if y'all want to do that, you can. If not, then it'll be set for trial. But I'm not going to give him a judgment satisfied.
We'll accept that, Your Honor.
Right, do y'all want to?
I can mean.
All right, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation? That's a class A misdemeanor. The range of punishment is anywhere from a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you enter the plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to confront any witnesses the state would call in the right?
This is where emotion meets the law. Adam's talking about grief, struggle, and trying to hold life together. But here's the thing. Courts don't measure pain, they measure compliance. Still, you can feel his sincerity. He's not making excuses. He's drowning in life's chaos. The question is, will the judge see heart or just another violation?
Right to remain silent. Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
That's fine.
Counsel voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find the defendant guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just ask the court follow the plea bargain, Your Honor.
All right. Are you the father of the unborn child?
I don't know yet.
Oh, well, that relationship is not going well if you don't know. All right. So this is what the court is going to do. The court is going to sentence you to 160 days in the Bexar County Jail, give you credit for any time served. There's a $500 fine, time and money to run concurrent. There's an affirmative finding of family violence. There's to be no contact with Digna, Digna, Maria Narvaez, Nevarez, Romero, outside of court proceedings. So if you're going to court to prove paternity or some other reason for going to court, then yes, but otherwise your relationship is over. Do you understand?
Yes, ma'am.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. You're going to have to make better decisions. Right? And if you cannot drink responsibly.
Boom. The judge denies the motion to revoke. Translation: Adam just dodged a jail sentence, but not the system's watchful eye. She's tightening the leash. Evaluations, random field visits, no unsupervised contact with minors. This is what we call judicial mercy with strings attached. One more misstep, and this whole second chance collapses.
And it causes you to have criminal cases, you should not be drinking. And there's nothing missing by drinking. You know what is a great drink? Sprite. And if you add a touch of lime to it, it's so refreshing. Coca-Cola, add some lemon to it, so refreshing. That's what I do. And Cappy's has a great drink that I've tried to duplicate and I can't. It's cranberry juice with lemonade in it. And the lemonade surrounds the cranberry, but it tastes so great. So there are other things, other drinks to enjoy other than alcohol.
I understand that.
All right, sweet tea, sometimes people put too much sugar in it, but oh well. Good luck to you, okay?
Thank you.
Thanks.
You're welcome. 2018 CR 9274W, State of Texas versus Javier Zepeda. Can I have parties announced for the record for the state?
Travis Banks of the state of Texas.
Defense?
I've moved for peace.
And are you Mr. Javier Zepeda III?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision,
Yes,
and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Are you the same Javier Zepeda III who was placed on deferred adjudication in 2018 CR 9274W for the offense of assault, family second offense on September 5th, 2018 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
I violated condition number 5 in Bear County, Texas. The defendant Javier Zepeda III did then and there fail to report to the supervision officer in person for the months of May 2020, June 2020, and July 2020 in violation of condition number 5.
How do you plead to that? True or not true?
True. The state will waive and abandon the other allegations in the motion.
All right, any objections?
Notice how the judge turns teacher here. Before you make a decision, ask yourself if it could land you in jail. That's not just for Adam. That's a masterclass in accountability for anyone watching. The courtroom becomes a mirror.
Yes.
Are your decisions leading you toward freedom or toward your own version of a sentence?
Objection.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court would find violation of condition number 5 true. Is there an agreement?
Your Honor, there's not exactly an agreement. The state is recommending that the defendant be revoked and sentenced to 5 years, but I believe defense has their own request for the court.
All right, defense, what are you requesting?
My client, his family, his employer, and I are requesting that he be allowed to do inpatient, to be allowed an electronic monitoring device, and to continue on probation. We would not be opposed to extending them as long as it's physically possible. And we have witnesses, we have some testimony we think the court will find relevant.
All right, probation?
Your Honor, this case expired in 2021.
New case, new energy, and it's getting heavier. We're now shifting to State of Texas versus Paul Andrew Martinez, a sex offense case. This isn't probation for a traffic ticket. This is high stakes, zero tolerance territory. Every missed counseling session here isn't just a slip up. It's a potential ticket straight to prison.
So an extension of probation at this time would not be an option.
Yes.
I understand, Your Honor. We have in the courtroom today, Mr. Joe Ricky Naranjo, his employer.
Mhm.
We have his mother, and we have his father. The problem here is that this man has been a heroin addict, Your Honor, and he's trying to bring that under control. Even while he had absconded, he has been going to get methadone. He's been going to the methadone clinic. And his mother's a witness to the fact that she takes him every day to the methadone clinic. And the father is here to testify that he himself has been on methadone for 10 years and is supporting his family and has a full-time job, is a supervisor, and he's a methadone user, and that's how he fights his cringes. And this young man is taking methadone.
So this is the question. Here's the thing. These are the answers I need to make an appropriate decision in this case. Now, even though I cannot extend you, I can find you guilty, and I can give you regular probation, but there are questions that I have that need to be answered.
Yes, ma'am.
And those questions are going to be, where has he been? And what has he done on probation?
Tell the court what program.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record, please.
Javier Cepeda III.
All right, off the record for a moment. Could I see the attorneys on, so where have you been?
I've been working, ma'am, and staying with a family member. I actually have 3 jobs.
All right, so you were in felony drug court
Yes, ma'am.
and you didn't do well. Felony drug court is a good program. And what I have is that you were sent to felony drug court. You were placed in ISF. You were returned back to felony drug court. And by the end of April 2020, you were testing positive for opiates and marijuana. You continued to use drugs. You were not in compliance with felony drug court outpatient treatment. And then you stopped reporting. And then you contacted your case manager. And I'm aware of all the parties in felony drug court because I used to be an attorney in felony drug court.
Yes, ma'am. I'm aware of that.
You contacted her in July 2020. You requested help.
Yes, ma'am.
So they arranged for you to go to detox, go to Center for Healthcare Services, and then be transitioned to lifetime residential treatment upon detox.
Yes, ma'am.
You entered detox, then you left detox.
Yes, ma'am.
Then a warrant was issued for you, and then you stopped communicating with felony drug court.
Yes, ma'am. I got scared.
Well, no,
I had a kid on the way, so I made a
don't
stupid
use.
Quick legal insight. Deferred adjudication means the court is holding off on finding you guilty, as long as you follow every rule. But if you violate even one, that deal disappears, and the judge can hit you with the maximum sentence. It's like walking a legal tightrope. One wobble, and you're done.
That fear thing with me. And let me just tell you why I don't use the fear thing with me, because I'm reading this and felony drug court. I know how they work. When people relapse, they don't immediately cut you off.
Yes, ma'am.
And that's evidenced by the report that I'm reading, that they gave you chance after chance. They sent you to detox. So you leaving detox, don't try to use your child as an excuse. I had a baby on the way, because that wasn't the reason why you left detox. You left detox because it got hard and you wanted to use, and you're continuing to use. So do not use your child as an excuse for why you are not clean and sober.
Yes, ma'am.
So I don't believe there's anything that I can do for you because felony drug court has tried it all. You absconded from felony drug court and they still accepted you back after you absconded. They were giving you help and then you absconded again. And I understand that there comes a point in time in people's lives where they're like, okay, now I'm ready to do it. But at some point in time, the court can't continue working with people who don't want to be worked with. And your problem is your chances to be worked with have elapsed. There is no chance to be worked with. You're going to have to do it on your own.
When he wasn't reporting, he was taking methadone to make sure he did not go down the spiral. He was trying, and his family's here to say that they worked with him with that.
But all he had to do was pick up the phone and call felony drug court. Have you read? I'm going to read this to you. You've been an absconder for almost 3 years. As an amended condition of probation due to a motion to revoke, Mr. Zepeda was placed in the felony drug court program on January 24th, 2019. That was me who did it. It says, Mr. Zepeda struggled to anchor in with outpatient treatment and admitted a drug relapse. And I can tell you, when I placed you there in 2019, I had to call them and say, please accept him. I know y'all are booked and don't have room for him, but he's on the edge. Can you please accept him? And they did. And then it says, as a graduated sanction, they placed you in the Bexar County ISF program on October 30th, 2019, and you completed it on March 3rd, 2020. You returned to the felony drug program, and by the end of April 2020, you were testing positive for opiates and marijuana. Mr. Zepeda steadily declined into further drug use and non-compliance with the felony drug court program rules and outpatient treatment. Mr. Zepeda fell off the grid and stopped reporting for the months of May and June of 2020. Mr. Zepeda contacted his felony drug court case manager in July 2020.
Here's the climax. The judge could have revoked Martinez's probation and sentenced him to 20 years in prison. Instead, she hits him with a 30-day jail sanction. That's a warning shot, a taste of what's waiting if he doesn't shape up. Mercy again, but make no mistake, it's the last one he's getting.
And requested help to regain sobriety. She arranged for you. They didn't say, oh, we're going to revoke you. We're going to send you back to the 187. She said, we're going to get you into detox. So they sent you to the Center for Healthcare Services. And then they said, after that, after detox, you're going to go into lifetime residential treatment. And you entered detox on January 7th, 2020. You stayed there for 2 days. They said a couple of days. In my mind, that means 2. And you left. A judge's warrant was.
And there it is, the final takeaway. In this courtroom, mercy comes with a message: accountability or incarceration. Both defendants got a second chance, but that's the last grace they'll likely see. The judge is balancing justice and humanity and reminding us that in the legal world, redemption always comes at a cost.